Morning. Thank you.
SJC-11133, Feeney versus Dell.
All right, let's proceed. Good morning.
Good morning. My name is John Shope, and I represent Dell and the other appellants. In 2009, this court held in this very case that a Massachusetts public policy favoring consumer class actions foreclosed the enforcement of the arbitration clause that the parties had agreed to in this case because it waived the right to proceed on behalf of a class in the arbitration. Now, last year, in the AT&T Mobility against Concepcion case, the Supreme Court of the United States held that the Federal Arbitration Act preempts any state law or rule that would invalidate an arbitration clause on the ground that a class proceeding would be unavailable in the arbitration.
Did it say that any state law would be invalidated? In other words, this is a 93A action, right?
Yes.
And under 93A, citizens essentially have the right to bring a class action, right? It's not a common law rule of any sort. It's a statutory right.
That's correct, but the Supreme Court has said repeatedly that that states may not frustrate the Federal Arbitration Act by legislation or by rule of common law.
Well, who's frustrating it? Why can't, okay, so there's a statutory right to bring a class action. Fine, the parties have agreed to arbitrate, so why can't the class action be arbitrated? What's the problem with that?
The Supreme Court said that there are three reasons why that is, in its words, quote, inconsistent and interferes with fundamental attributes of arbitration, and that's at 131 Supreme Court.
So arbitration, class actions can't be arbitrated? I've never heard of such a thing. They can't do it?
Well, what the Supreme Court said in Concepcion is that while parties in theory could agree to class arbitration, it would be fundamentally inconsistent with arbitration as contemplated by the Federal Arbitration Act, and it gave three reasons why that is so.
All state statutes that create a right to bring class actions in consumer areas, wage law areas, are simply preempted.
They're preempted in cases that are subject to the Federal Arbitration Act, which of course is the great majority.
Wipes out the, I mean, you have 93A, and 93A is a statute of general operation. It doesn't focus on trying to undo arbitration. I mean, that weighs in here, doesn't it?
Well, that was the argument that the dissent made in the Concepcion case. Justice Breyer made that argument. Four justices obviously had that view, but it was rejected by the majority.
But in Concepcion, you have a case where I'm somewhat switching gears, but you have a case where the issue that the court found inconsistent was arbitrating this class action. And I guess the combination of having a statute that is of general import and having, as I read our Dell decision, having a determination that if you can't bring a class action, you cannot, in substance, vindicate the right, also goes?
So I would say two things. First of all, in Concepcion itself, in that very case, the California statutes under which the plaintiffs were asserting their claims did explicitly provide for class actions just in the same way that Chapter 93A does. So that's simply not a distinction between the cases.
But could I ask you to focus on the question that was answered in Concepcion, which was whether the Federal Arbitration Act preempts states from conditioning the enforcement of arbitration on the availability of particular procedures, here, class-wide arbitration, when those procedures are not necessary to ensure that the parties to the arbitration agreement are able to vindicate their claims. And in Concepcion, you had quite a different arbitration provision than the one that we are asked to consider in this case. And it was considered to be quite friendly to the particular rights that were sought to be vindicated.
So I think that's the nub of the case. And the point there is a very simple one, and that is that it is the reasoning of the Supreme Court's decision that controls, not the particular facts. When the Supreme Court wishes to have its holding limited to the particular facts of a case, it says so, just as this Court does.
But,
Now,
didn't it create a two-step process or a two-step inquiry? And the first being, does the state law prohibit outright the arbitration of particular claims? Isn't that the first question that we have to answer?
That may be the first question, but that was not the ground of the decision in that case.
That may be, but so the answer to the first question is no. There is no Massachusetts statute that prohibits the arbitration of 93A claims. So then, don't we look to whether or not Chapter 93A has been applied in a particular way that disfavors arbitration?
Yes, and that's exactly what the Supreme Court said. And the Supreme Court said that requiring class-wide proceedings as a condition of enforcing the arbitration clause is fundamentally inconsistent with arbitration as contemplated by the Federal Arbitration Act.
But what has Massachusetts done to discourage arbitration of 93A claims?
Because Massachusetts and other states had said that it would not enforce the arbitration clause unless a class would be available in the arbitration. And the Supreme Court said that there are three problems with that. First of all, that basically class arbitration would create endless proceedings, what the Supreme Court called a procedural morass. That's point number one. Point number two is that class proceedings require the protection of third parties. And so that requires a high level of formality, which is inconsistent with arbitration. And number two, that it would require expertise on the part of the arbitrators with regard to protecting the rights of absent parties, which they typically last. And third, if I might just continue, because I think this is a highly important point, what the Supreme Court said as its third reason was that if companies are required to agree to class proceedings as a condition of arbitration, they will be far less likely to put arbitration clauses in their agreements. They will be unlikely to agree to arbitration because that would essentially, as the Supreme Court said, bet the company on a single case. You have an arbitration where there are extremely limited rights of appellate review, essentially only for misconduct of the arbitrator. There's very little ability to correct errors.
Exactly why they want you,
And
right?
well, that's indeed one of the advantages of arbitration is that it is, as the Supreme Court said, streamlined. It's speedy. And so what that means is you waive appellate rights. But what the Supreme Court is saying is that if you combine that, if you marry that to the huge liabilities of a class-wide proceeding, companies are not going to agree to arbitrate.
So,
And this frustrates, as the Supreme Court has held, this frustrates the purposes of the Federal Arbitration Act.
let's imagine there's a provision in an agreement which says that where there is a dispute over a relatively modest amount of money, the customer has the opportunity to challenge the issue and dispute it with the company. But if the company does not agree, the consumer has no recourse to challenge or to litigate the dispute. Would we be permitted to claim that that was unconscionable?
I don't believe that the Concepcion case would foreclose that by itself, because the question would be whether it was a rule of general applicability that did not discriminate against arbitration. And so if the customer simply waived any right, whether it was in arbitration or in court, then it would have to be analyzed under the general standards of unconscionability, which in this state include procedural as well as substantive unconscionability.
State could do that. Why can a state not say that when an arbitration provision makes it effectively unrealistic for any consumer to challenge a claim involving a modest amount of money, that that has the same effect, and therefore that that you can have an arbitration agreement, but where it turns out that it is economically unrealistic for a consumer to challenge it because of, say, the cost of arbitration, that in those cases, and only in those cases, will we refuse to impose arbitration upon the consumer
And-
in order to give the consumer the opportunity to litigate?
Sure. And the answer to that is very straightforward. Class proceedings, the Supreme Court has held, are, quote, inconsistent with arbitration as contemplated by the Federal Arbitration Act, and class proceedings interfere with fundamental attributes.
Is that what Brewer
I'm not
and
proposing that you would impose arbitration. I don't think anybody is suggesting that we would impose class arbitration on the company. It's simply to say that when the company does not provide the opportunity for individual arbitration, as AT&T did, then we reserve the right to pursue in a court a class action.
Yep. Well, that's the argument that the plaintiffs are making. They're saying that this relates only to, quote, manufactured class arbitration and doesn't apply in a situation where the court orders that the case proceed with litigation in court. And there are a couple of problems with that. Number one, the facts of Concepcion are indistinguishable. That was a case where the court had refused to enforce the arbitration clause and had ordered litigation to proceed in court, just as this court did.
Facts are not indistinguishable because in Concepcion, as Justice Duffley said, there was very friendly, consumer-friendly provisions within the agreement, and there are not here.
And what the majority of the Supreme Court said, and I'm quoting here, that was what Justice Breyer said. Justice Breyer said in the dissent that many customers are not going to pursue their claims because they don't want to be put on hold, they don't want to spend time filling out the forms. So even though there were the special penalty clauses, many customers are not going to they're not going to bother.
There's a difference between a finding of it's not convenient to do so and a finding that in substance is you are precluded from doing so because the economic cost is just too great.
Sure, and I have a couple of answers to that if I could give them. First of all, the majority of the Supreme Court said explicitly that small dollar claims will slip through the legal system, but, quote, states cannot require a procedure that is inconsistent with the FAA, the Federal Arbitration Act, even if it is desirable for unrelated reasons. That's 5 justices of the Supreme Court. And that is not dictum, as the trial judge suggested. It follows directly from the reasoning of the case, which relates to why it is that class proceedings interfere with fundamental attributes of arbitration as contemplated by the Federal Arbitration Act. Secondly, I would say in this case that there is actually, if I could answer, may I answer the question that Justice Brodsford has asked?
I didn't realize you hadn't completed
Sure. And because I think it's an important one. And the distinction was just drawn between inconvenience versus inability to vindicate the claim. And I would point out that in this case, there is absolutely no factual record to support the notion that it would be unable for a plaintiff who wanted to spend the time. I think most people are not going to spend the time
I mean, $1.31 claim that's going to cost several $100s to pursue, or in the case of the business entity, a $200 claim that's going to cost several $1,000s to pursue, is that going to prevent them from doing this?
Under Chapter 93A, if the claim is meritorious, all of that money, all of that expense can be recovered, because Chapter 93A provides for an award of attorney's fees. It provides for all the costs to be repaid.
After the fact.
After the fact. But that does not go to an inability to vindicate. What it goes to
Well,
is...
sure it does. It goes to the ability of the person to get a lawyer who's willing to undertake this kind of a case in the first place.
There was absolutely no evidence in this case, and I think that the evidence is contrary, that Dedham Health, if it was so inclined, would not be able to go out, hire a lawyer at an hourly rate, and prosecute this claim if it wanted to make a point. And I personally, in 20 years of litigation, I've been involved in many cases where I thought parties were pursuing cases that weren't necessarily the most economically rational to pursue, but they were doing it because they wanted to prove a point. And there was a case reported in the Lawyers Weekly 2 weeks ago where a party had lost I believe $12,000 and brought a 93A claim and ended up with an award just of $98,000, just under $100,000.
Yeah, and I know a law professor that took a speeding ticket or a parking ticket case all the way up to this court. But that doesn't, the fact that there may be 1 or 2 people out there that are willing to crusade an issue doesn't necessarily mean that that's the generally commercially general experience.
Well, to me, it's simply rank speculation whether or not someone is or is not going to want to spend the time. I mean, in the case that you're going to hear following this one, the actual damages that the individual plaintiffs have suffered before you get into multiplication, as I understand it, range between $28,000 and $65,000, and yet the plaintiff's lawyer is saying that no, the people aren't going to bother to pursue that. So the problem is that this is what Justice Scalia said in his opinion, joined by 4 other justices, which is that that is simply a toothless and malleable standard. There's simply no way to draw the line. So,
But you know what's incredible about that? When you say rank speculation, we have a pro bono rule in our rules of professional ethics, and we go around the state crusading and encouraging lawyers to undertake pro bono cases. Something like 55 or 60% of people in divorce cases can't afford a lawyer. There's got to be an even higher percentage of people that can't take a $15 claim to small claims.
So, well, at a minimum, there was no evidence of that. I would also say that the whole vindication theory is expressly limited to cases under federal statutes, and that's because the Federal Arbitration Act commands that the arbitration agreement shall be enforceable. There may be, as the Supreme Court has said repeatedly, a contrary command of Congress, but it has to be a command of Congress
Where is it
itself.
specifically precluded that vindication of effective vindication of rights may not be extended when we consider conscionability in the contract? I know it's been generally upheld in cases where there's a federal right at stake, but where has it been precluded that states consider vindication of rights?
Well, we cited the CONF decision from the Ninth Circuit is the one that most recently applies.
You
We cite some other
you don't mean
cases.
a Supreme Court case.
No, but the Supreme Court cases have said specifically that the only ground for considering vindication, they've said this is most recently in the Compuwood versus Greenwood case this year. They said this in the Shearson-Lehman case. They've said it in the Mitsubishi case. And what those have said is that Congress itself may countermand the Federal Arbitration Act. But obviously, Chapter 93A is not a command of Congress.
If I ask one more question. Sure. I gather in California there was some procedure by which an arbitration could be made a class arbitration without the agreement of the company. Is that in fact the case?
That is correct.
And is that, and much of the discussion in the AT&T case focuses on the unfairness of that possibility to the company. What is the consequence of there being nothing in our law which would impose class arbitration on a company without the company's agreement?
I believe there's absolutely no consequence because, as I say, in the California case, what the trial court had done is exactly what the court had done here, which was to refuse to enforce the arbitration clause in order that the proceedings go forward in court. And we've cited some other cases that have subsequently explained that the states may not simply refuse to enforce the arbitration clause on the ground that, well, we're going to avoid the evils of class arbitration by refusing to enforce the clause, because the Arbitration Act says explicitly that the clause shall be enforceable. That's the first requirement of the statute. Now, there is a savings clause to the statute that says that arbitration can be refused on grounds that are generally applicable to all contracts under the law of the particular state. But what the Supreme Court says is that such a rule cannot be applied in a way that disfavors arbitration, and that's the requirement of class proceedings, for the reasons that have been enumerated, disfavor arbitration. So from our point of view, that's the beginning and the end of the story.
Mr. Shope, we'll have to leave it there.
Yes.
Thank you.
Thank you.
Good morning, Mr. Chief Justice, members of the court. My name is Ed Rapacki, and I have the privilege of representing the plaintiffs' appellees in this litigation. I'd like to, boy, you guys had some great questions.
Well, here's one for you.
Sure.
What about, why isn't the availability of a class action in 93A to so many people, why isn't that virtually an obstacle to arbitration?
Sure. Remember, the Congress passed the Federal Arbitration Act to remediate a historical bias against arbitration from courts. And what Supreme Court has said many, many, many times is the Federal Arbitration Act is designed to make sure that agreements to arbitrate are treated no worse and no better than any other contract. So let's posture this. Imagine Dell's terms and conditions exactly as they are, with one exception. Instead of the paragraph being entitled Binding Arbitration, it said Dispute Resolution. And instead of requiring only arbitration before the National Arbitration Forum, it said, you give up the right to any class action. Any dispute between us has to be resolved on an individual basis.
Wherever, whether in court or...
Just doesn't even mention arbitration. Under this court's decision in Feeney 1 in 2009, that contract would not be enforceable in this case. Why? Because under the circumstances of this particular case, these claims, these damages, it would prevent the plaintiffs from vindicating their statutory right under Chapter 93A to have a class action.
Yeah.
Now, what the defendants are proposing, what their rule is saying, is that because it's an arbitration clause that class action ban appears in, this court cannot enforce Massachusetts public policy. What the defendants are saying, even as they go even further, and to say the fact that these plaintiffs and others would not be able to vindicate their small dollar claims is but a small price for society to pay in order to preserve the principle of arbitration, even though there's never going to be an arbitration. That treats arbitration as a fetish. That's not a dispute resolution, because there's never going to be resolution of the dispute in arbitration.
But let me ask you this, though. I appreciate that is the history of the Federal Arbitration Act, that it was to sort of level the playing field for and dealing with historic hostility to these claims. I think the defendant, Dell, would argue, well, that may be historically, but Concepcion has changed the playing field.
Okay.
And so maybe you can focus on Concepcion.
Absolutely. So in Concepcion, as Justice Duffley said, the question that was presented is whether or not the California Supreme Court's common law rule in Discover Bank.
It was part of a statute.
No, it was not, Your Honor, with respect.
There was a statute about unconscionable contracts, right?
There was a statute that said it is against the public policy of California to allow to let companies get away with schemes. The claims themselves were asserted under common law and under a Delaware statute, neither of which contains the class action rights that our legislature enacted in Chapter 93A. So that's the first difference. The second difference is that the lower courts, both the District Court and the Ninth Circuit, held that the particular arbitration clause that AT&T used, under that clause, individual litigants would be better off in an individual arbitration than they would be as part of a class action. And that is, remember, the Discover Bank rule, what the Discover Bank rule is very different from what this court declared in Feeney 1. The Discover Bank rule says, if there is a contract of adhesion, And if the contract of adhesion occurs in a transaction which commonly would give rise to claims of a small dollar amount, and if to enforce that arbitration contract, companies would essentially be exculpated from small dollar, high volume misconduct, then the court, as a matter of common law, would impose class arbitration. In fact, the California Supreme Court in Discover Bank reiterated what it had said earlier in Sutherland. That is, class arbitration is, we believe class arbitration is more important and better than not enforcing the arbitration agreement. Yes, Your Honor.
Okay. So what we have in Feeney is the court says, well, this clause doesn't work. There's no, we're not suggesting, in fact, the clause doesn't work. There is no class arbitration. But what that means is you don't get arbitration, right? Because, yes, an individual could individually arbitrate, but is free to bring a class action in court, right?
Correct.
So in that sense, how is that not disfavoring arbitration? Because the individual can just bypass it completely, even though it's part of his contract.
Actually, I have three quick answers to that. One, the consumer can't just bypass it. Remember, in California, the Ninth Circuit and the District Court were compelled to apply the Discover Bank rule, even though it would not have any benefits to the individual plaintiff before it. In other words, even though the individual plaintiff would be better off. This court didn't say that in Feeney 1. Second of all, this court made it very, very clear. In fact, its decision presaged Stolt-Nielsen. This court said, hey, there's no agreement. There's no way we read that agreement to allow class arbitrations, and therefore we can't order Dell to arbitration, class arbitration. And remember, that's how the Discover Bank rule works. Now, it's true in Concepcion that faced with that, the defendant said, okay, then we don't want to apply our arbitration clause. But that's why the Concepcion talks about the state cannot impose a procedure that conflicts with the Federal Arbitration Act.
Now, in our case, picking up on what happened in California, if there had not been a 93A action, but simply a common law count, of whatever, breach of warranty,
Yep.
And you had initiated a civil action and a class action under Rule 23, same result? Same result as you're arguing for here now? No state statute, no 93A class action?
I would make the argument that yes, because for two reasons. First of all, just last Friday, the Court of Appeal in California decided the Franco case. And that's at 2012 Westlaw 5898063. And in that opinion, the California Court of Appeal talked about the history or the law and the difference between Discover Bank, that rule, and its Gentry rule, rule in Gentry, which is what this court's Feeney 1 rule is more like. Gentry says where to enforce an arbitration agreement would deprive a plaintiff of the forum in which he or she could effectively vindicate their claims, statutory claims, then the agreement, the arbitration agreement cannot be enforced.
As
Now,
a matter of unconscionability?
yes. Now, remember, any time that an arbitration agreement is denied enforcement on grounds of unconscionability, duress, any of the grounds that public policy, any of those grounds that Section 2 of the Arbitration Act permits.
Well, not public policy.
Not
is
sure
one
about
of them.
public policy.
Actually, I would differ. It simply says grounds that are common among all contracts, such as. It doesn't exclude it. And in fact, Professor David Horton is about to publish an article where historically, at the time of the Arbitration Act, between 1923 and 1925, arbitration clauses or contracts were denied enforcement in common law cases, mostly for unconscionability. And the second most predominant doctrine was public policy. In fact, the contracts that were not enforced on grounds of public policy were greater than the sum of all the others, duress and the others.
Well, if I could focus a little bit on the, are you familiar with the Brewer case?
Yes.
It just
Missouri,
came out
yes.
recently.
Yes.
Which was interesting because it was one of those that was on remand.
Correct.
And then cert was denied. I don't know if you can read much into it, but it was denied. And in other decisions recently, the court has entered per curiam decisions. So now this was, does this help you?
Yes,
on
it
this
does.
issue? And in what
for
way?
precisely the reasons that
That's
you
a
were
lot. Go
indicating
ahead.
earlier. In Feeney 1, this court talked about, look, arbitration, all of these doctrines, unconscionability, the federal law of arbitrability with the effective vindication of statutory rights, the public policy and class, it's all designed, they all share commonalities, and that is, does the particular arbitration agreement at issue provide may not be the greatest forum, but a valid forum for dispute resolution? And that's what Brewer talks about. It
And
really goes to
effective.
unconscionability, and they do look at other factors. But just because a state declines to enforce an arbitration agreement that may contain a class action ban does not necessarily violate the Federal Arbitration Act. Remember, in Concepcion itself, that was an application of conflict preemption. And Justice Wilkins, or Judge Wilkins in the Superior Court here, grasped the significance of that. Unlike Marmot, which is that Supreme Court where West Virginia said,
Nursing homes.
right, exactly. So in a conflict preemption, you look at the particular circumstances, and the presumption is that the state law is not preempted. Here, one, I don't think that this court, if this court were presented with the same facts as Concepcion, that's really the test, right? Would you guys have come out the same way as the Ninth Circuit did?
Well, we don't have a discover rule.
That's what I'm saying, right? But if that were the situation, in other words, if the arbitration clause was such that our clients would be better off in an individual arbitration than they would in a class action, would this court have denied enforcement of that arbitration clause? I don't think Feeney 1 goes that far.
If class certification is denied, can the business then, or can the defendants then renew a motion to recommit to arbitration?
No. But they will be able to raise the issue on appeal. And that's the other part here. Remember, we're here on a 231-118. This court declared the law in Feeney 1. When we got back to court, this court, right, the order compelling arbitration was reversed. We got back to Superior Court. We amended our complaint as the court instructed us to do. The defendant answered the complaint, and in the defendant's answer, it asserted arbitration as a defense only with respect to class members who were not the plaintiffs. If we go through the litigation, by the way, they did not seek cert, even though they could have under Sutherland. They could have sought cert from the United States Supreme Court from this court's Feeney 1 opinion, but they didn't. They preferred to reserve until, I would assume, until a normal appeal. But what they're asking here on an interlocutory appeal is they're asking you to not to follow the Supreme Court, but to go even farther than the Supreme Court did. They're asking you to say, as long as there is an arbitration ban in a class action ban in an arbitration clause, we are not going to permit enforcement in state courts of Chapter 93A claims. That one sentence that Mr. Shope quoted, that's a lot of heavy baggage that one sentence is supposed to be carrying. The Supreme Court never said that. And by the way, in Preston versus Farrar, the Supreme Court applied that effective vindication of statutory rights to state claims. It is true that in Mitsubishi they talk about federal statutory claims, but that's because it was federal statutory claims that were at issue.
You're going to have to wrap it up, Mr. Rapaki.
I would like to add, thank you, Mr. Chief Justice, I'd like to add that we do have an argument that because this court reversed the order compelling arbitration, we're back to square one. And this court can uphold Judge Wilkins' decision because Dell, in its agreement, the terms and conditions, reserved the right to change those terms and conditions at its own discretion at any time, meaning we file a claim and Dell could say, no arbitration before the NAF. You could have arbitration before the American Arbitration Association at $10,000 a pop. We cited plenty of cases to that effect. So thank you very much.
Thank you.